you, Rita. Thank you, thank you, thank you. I can see you. Thank you for being here.
Hi.
Thank you much. Yes. We still have just about 2 minutes. Hopefully, people turn in early
No
so we
problem.
can keep time.
Is my audio okay?
Yeah, it's fine. It's fine. It's
Okay.
Shay, if you could hear us, could you please drop a message in the comment section? Could you send a message in the chat? I think this one just tuned in, but he's not saying anything.
Okay.
How are you now? Before they come online, self, how has it been? Network, don't do this.
One day at a time. Can you hear me? Oh, hi, Shay.
Yes, I can hear you. I can hear you.
You can't hear me. Can you hear me? Hello, Vivian. Can you hear me? Let's see now. Vivian, can you hear me?
Yes, yes, I can hear you. Can you hear me? Can you hear me?
Yes.
Oh,
Okay.
okay. Let me see. Sorry, sorry. I'll bring you back online. Just give me a few minutes. Okay. Could we just give the rest maybe 5 minutes? What they call it? 5 minutes for some other persons to join us. 5 minutes, Grace. This is the first time I'm using this live restream to actually do something like this.
Okay. I guess we'll figure it out, but I'm not sure
Yeah.
there's going to be any
But the
issue,
way,
save for network glitch.
yeah, but the way it is right now, so we are streaming live on YouTube and LinkedIn. So I think the way it works, you could use it to stream on multiple platforms, basically.
Mm. I think there's an option for you to go live when you're ready and not like
We are live,
immediately you
actually.
join.
We are actually live. I've gone live.
Okay.
Yeah.
So we just wait for everyone to come and then.
Yes, yes. Let's do that. How is work? How is lecturing? Are you lecturing IP or just a different course altogether at the school?
Different course for now. They haven't introduced IP yet, but they said next session.
Okay.
So
Hmm. The better.
hopefully when they do that, we'll see how that goes. But I would say it's a
Yeah.
good
What course are you taking?
land law at the moment. Then
Oh wow, that's a deviation.
it's still within what's it called? It's still within property, tangible and intangible.
Yeah,
So
it is, but it's tangible you're doing now.
yeah, I'm doing tangible for now. So what have you
I
been?
think
How's work?
fine, 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 fine. Work is good. I don't think I have the strength for lecturing. I'm not really a patient. person when it comes to grilling me with questions. So
Interesting.
I'll be doing myself a disservice and the people that will be put under my tutelage, so to speak, a disservice to lecture them. So
Mm.
I just feel it's not something I have passion for. So I don't want to come and then I explain one thing over and over again and they're not getting it. I get irritated easily with that.
Ah,
I
well,
give it up for lecturers.
so,
I do.
oh well. It's just another career path that we are exploring at the moment. We'll
Yeah,
see
it's
where
a
that
good
leads
one
to.
too.
We'll see where that leads to.
Well, how many? I can't even see apart from Shay and yourself. I can't see how many more persons are online.
Oh, maybe there might be
Yeah,
an issue, or you guys might probably have to do like a reminder. What?
yeah, I'm doing that now.
Okay then.
Someone even reminded them 12 minutes ago.
Oh, since it's just Shay, Shay, if you have questions, please start putting it now so that why we are
Exactly. Don't
doing.
forget, me, I have loads.
Ah, if you are scaring me, say you have loads of questions.
But no, don't mind. This IB International Bar Association, the conference coming up. I don't know if you followed them. They put up for those who want to be sponsored. So they put up scholarship, and interestingly, for those writing under intellectual property law and IT communications, the question was, how do you protect intellectual property rights and privacy in the metaverse, which is also just a branch of frontier technology, the whole of this thing. And it was interesting actually to see
Did
that
you apply?
this topic is not going anywhere. I did, but see these people, you will fill one form while before you submit your essay, right?
Yeah.
And then in the form they asked for English speaking certificate. I'm like, for me to even write this thing in the first place, I sent them a mail. They took time to respond, but by the time they responded, I just attached my undergraduate transcript.
Okay.
The guy responded that it was okay, so don't know when they will get back to us.
Fingers crossed then.
Exactly. The conference is in Paris. It will be an opportunity,
Yeah, most of the
and it's
international
all
conference is always good to attend at least once if
yeah,
you can.
yeah, it
It
is.
just gives you that exposure and then you're able to network with people from other
Exactly.
jurisdictions as well.
And it's all expense paid. They sort out your flight, your accommodation, and they still give you a stipend of is it £50 or €50
Wow,
for the each day for the duration of the conference.
that's very thoughtful of them then.
Yeah, apparently they do it every year of the conference. Yeah. I'm sure the competition will be very, very strict.
Yeah, probably just put it in my diary for next year. Too many things in the diary for next year, so
Exactly. I think for me, it just gave me an opportunity to research on the topic basically and also get to know what's happening. Because these days, it's open book read.
but you can open novel and social media and ebooks.
I don't even read those anymore.
Interesting.
That's the thing. I don't like when I pick them up. I'll just ask myself, is it not better to read what will benefit my career now than read this, and then I drop it, and instead of reading what will benefit my career, I'm just like, oh no, 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 no. I'm tired of reading.
So no advice from you on how to start reading because we do it
You
very
just tell yourself, okay,
just
maybe I want to go back to another master's or PhD to help you read.
that one today. PhD is
To help you
another one,
read.
maybe sometime in future, but yeah.
So,
Uh,
yeah, you're in the academic field, so doing a PhD would be a nice one.
it is. We're looking for scholarship first of all, so it's not cheap to do a PhD. So
Seriously, seriously, it's the other day I was just going sometime last year. I just told myself, let me just see how much for just average, not the exact salary, maybe an estimate a year for law. In if you're looking for a school that is renowned, so to speak, in the UK, a year is like £17,000. That's just the school fees,
excluding
excluding rent,
accommodation,
legit. And
Re-
you're paying this for 3 years.
3 years. That's if you finish in 3 years. Oh, don't finish in 3 years. Just
But you have to push yourself to finish it 3 years. Oh.
I
Let me see if most people are on YouTube because some persons can join you by YouTube. So we could just start.
okay then.
Mm. Actually see us on YouTube. As I switched to YouTube, it's as if automatically switched to the YouTube. Um, so far it's just Shade has shown that he's here, and let me call. Oh, it says guest is trying to join. Room is full.
I think
Can you
some
hear me?
other persons are logged in on LinkedIn
Ye-
as well.
Okay. Yeah, but it just showed me that some persons are trying to join, but the guest option is full. So I don't know how that is happening.
They can they join in as guests or participants now? I don't really know.
They have to join as participant, but that's the person yes, I think people are trying to join. The person I conversed with asked me to send the link, this link to them. So I'm wondering why. I mean, I think let's start in the next 5 minutes because they can't join. It's showing me the guest is trying to join. Room is full. Hmm.
Shay, you don't go anywhere, stay.
So let me just let them know to join on YouTube. Okay, Rita, let me, sorry, give me a few minutes.
So, Vivian, someone just sent me a message. It says the room is full. So, I think you might just have to put a message that if you can't log in here, just participate on LinkedIn or on YouTube. This stream is probably for just the host and the speaker per se. But I think people are joining in on LinkedIn and YouTube. I don't know if you can hear me, Vivian, but she's not here anymore.
All right, Rita, let's start. So, can you hear me? Okay, thank you guys for. I've seen someone has joined us. Thank you guys. Thank you guys. Thank you guys for joining. So most persons, the room won't contain everyone. It's limited, so you have to stream it via YouTube and LinkedIn. Yeah. So basically, we're going to be looking at artificial intelligence and intellectual property rights. It's a very interesting conversation, and it's one discussion that is not going away anytime soon. It's been on the forefront in the past years, and we've had the World Intellectual Property Organization leading conversations on that. Sometime in 2020, the 2020-2021, the UK government published a call for views on the relationship between AI and IP. And some of the questions that were raised were respect to who would own the intellectual property rights in AI generated works, and should it be the human, should it be the machine, and where there is an infringement, which of the rules should apply, who would be held responsible. And in this webinar today, we have the famous IP and IT expert. She's good. Trust me, guys, when I say she's good. Yes, she's going to be taking us through. It was we deliberately didn't restrict the IP rights to maybe just copyright or patent, so that she would touch as much as she can for us to learn. So please, guys, hope you have your pen and paper. You have to jot things down. We promise that it's going to be a very interesting section, and I'm going to drop our email on LinkedIn and YouTube. So if you have any questions that you can't send here, please forward your questions and we'll try as much as we can to, get back to you with responses after the conversation. So taking over from me for the next 45 minutes will be Miss Anguri Rita Chinda. She's a lecturer, River State University of River State University. She's an IP and IT expert, and I don't want to read her profile because, guys, it's intimidating. But she's one person I really admire in this field. She's worked for it and she's proven herself time and time again that she's actually good, which is why I really wanted her to take us on this section. So taking over from now, Rita, please take over. Thank you. I'll be turning off my audio.
Okay, good evening, everyone. Okay, good evening, everyone. It's a pleasure to be here to discuss this topic. Please don't listen to what Vivian has said so far. I will do my best to be able to talk about the conversation because it's still an area that is, still being researched on. No one. I'm not an expert, still learning. So, when Vivian reached out to me, I tagged my presentation, um, Artificial Intelligence and Intellectual Property Rights, a beginner's guide. So, why a beginner's guide is so that people that are listening will not feel that it's just big English within the conversation, but I'll do my best to, talk about it the best way I can. So, in my presentation, I have five topics that I will run through, but these five topics are just so that when you eventually get the slides, you're not scared as to how short or how vast it might be. So first up is introduction. I'm not sure how many of us know what intellectual property is, but if you do know what intellectual property is and what it means, please put your answers in the comments section. I can actually see them from my slides here. And the long and short about IP basically is IP focuses on human intellect that must be commercialized. But then when you bring it down to artificial intelligence, the conversation changes as to what intellect are we talking about? Basically, intelligence by machine. That's like the long and short of what AI is about. Now, both artificial intelligence and intellectual property are intangible assets that can be applied to business, that creatives and inventors can also explore and can be used to solve and provide various services. Then, for artificial intelligence, you're going to be dealing with uh, neural networks, large language models, deep learning, machine learning, which are like the core and basis of modern AI in the fourth industrial revolution. While for creatives and innovators, elements which must be considered would be that it has to be commercialized. So if you're not using your intellectual property for commercial purpose, there's no point with you actually delving or creating something because the goal is basically to be able to monetize it the best way you can at the end of the day. Then I have what I call the handshake. So what the handshake basically focuses on is the issues that you may get to experience or encounter while you are doing your research. in this area? Are you actually creating the work because you're not going to be bothered as to authorship in terms of the type of intellectual property rights, or the subject matter in question, or the measures that you have to put in place when you are considering um, putting it out there in the market? Then we already know that intellectual property, we have five major forms of intellectual property. But when you relate it to our topic, which is focused on just artificial intelligence, you will be looking at three major forms of IP. So I'll list the five major types of intellectual property and then list the relevant intellectual property that AI, those within the AI space might want to, pay close attention to. So you have copyright, which basically protects literary and artistic works that are original in character, in whatever quality, um, as long as it's in a tangible format, such as the software codes, that's your object code and subject code, UX, UI interface, music, pictures, art, videos, and books. Then you have trademark, which will protect the name of your AI tools, the logo, the sign, the symbol affiliated with it. Then design rights will protect the visual appearances of your product or the combinations of lines and colors. Then you have patent, which will protect inventions in all fields of technology. And then you also have trade secrets. Trade secret protects confidential information of your business that gives you a competitive edge in the market. I was saying that the big tech companies, everyone is kind of gunning or wanting to explore, or even produce or make their own intellectual property or AI related tools that they can actually use to be able to solve certain issues going on in society, or provide services for creatives, or try to make the job of an inventor easier. So, for instance, I know this year what has been trending within the creative space is the Chat GPT, which is a form of the AI tools or model. Then we also have the likes of Mid Journeys and Dale that are used to create pictures. So, in the course of our conversation, I'm going to also talk about three major cases that most people in the intellectual property space were released that are relevant to the AI space. Then first, you have copyright. Now, for copyright, you have, um, sorry, hold on, please. My laptop is acting up a bit. Okay, sorted. So for copyrights, you have the case which I want to point to attention. We talked about the involvement or the use of AI, and that is the Zara of the Dawn case in the US. So most of the cases I'm going to talk about are mostly foreign cases, but we have one that is kind of it was in Africa, in South Africa. So I would say that kind of puts us in the limelight when it comes to AI and all of those conversations. So for the Zara of the Dawn case, um, the artist in question, Christina, had used Mid Journey to create a picture, and then she went ahead to, register the copyrights in the US. So under our present law, under the new Copyright Act, what the act now provides is that um, you may register your work. However, in jurisdictions such as the US, it's mandatory that you register your copyright so that in the event of a dispute, you have the leverage to actually sue anyone who uses your copyrighted work, whether it's a literary, artistic work, musical work, artistic work, sound recording, whatever form of the literary or copyrighted work it might be. But in in the Zara of the Dawn case, she filed the application, but did not disclose to the copyright office that she actually used an AI tool to create the picture of the girl that was in the cover of her book. It was only after they had given her the copyright of the work, and then she did like a social media post stating that we now have the first AI registered work, and the US Copyright Office were not having any of that. They had to call her back and ask her to reapply and properly disclose in her application that she actually used an AI tool to create the comic book. It's an 18-page comic book. So she had to do the application again, and then she was given a partial copyright for that work in question. She wasn't given full copyright because under the US law and under most country copyright law, AI, so far as you're not human, you're not a natural person, you can't be granted intellectual property rights, whether it's for copyright or for patent. So she was a bit upset about that, but you can follow her on either on LinkedIn. I follow her on LinkedIn and Twitter as well to see her conversation. She's exploring Mid Journey and AI and trying to see how they can actually engage the US Copyright Office to allow non-humans to be recognized as authors. Now, under our Copyright Act, what an author is defined. Hold on, let me just bring that up. I had it a few seconds ago. An author under the Interpretation Act is that's under Section 108. An author is defined as first you have for audiovisual work, it will mean the person by whom the arrangement for making of the audiovisual. Audiovisual is basically for cinematography works were made unless the party to making the work states otherwise in their contract. Now you see, I don't know how many of us are following the AI conversation, but you've seen that. I think it was on LinkedIn. I saw that post where someone made a movie using AI tools. So the creative space is rapidly developing. But then when you look back home, you begin to ask yourself, are we really ready to carry on or take the responsibility or the jobs that are coming? Then you also have collective works for an author to mean the persons responsible for selecting and arranging the collection. Then for photographs, means the person to be photographed. For sound recording, the person who made the arrangement. And for broadcast, a broadcast transmitted within any country means the person by whom arrangement for the making or transmission from the country we're taking. So you see that when you're talking about AI and copyrights, issues like authorship would definitely present itself because it's who the law recognizes as the author that gets to commercialize all of the benefits that a copyright owner is set to enjoy. Then you also had the case of um, the Heart of on My Sleeve viral song. It was an AI song that was created that went viral. It was an imitation of Drake and the Weeknd. And the record label companies were not having any of that. Now, conversations have been growing amongst record label companies as to who can actually use AI tools or script data from the internet to be able to generate uh, music. Now you find out that when it comes to AI and copyright, going to be hearing more of generative AI works. So whether it's a book or a music or picture, whatever it is, they're all considered to be generative work. So for the Weeknd's case, the record label, which is Universal Music Group, complained that the person who actually created the AI song, mimicking Drake and The Weeknd, violated their copyright. And then the question now is, can a voice be considered to be an expression of a copyrighted work? Because intellectual property basically does not protect an idea unless in form of a tangible format or um, as a form of a name, word, logo, and invention, whatever it is. So I would refer you guys to also look at or read section 54 of the Nigerian Copyright Act, which talks about um, take down notices of copyrighted work and what you can do in the events where your work is being infringed upon. Then my final case that I'm going to refer to when you're talking about AI is the case of the Davos AI by the scientist Taylor. I don't know if I'm pronouncing his name well, but that is his name. So his name is Stephen Taylor. So he, sometime in 2021, made a patent application for an AI generated invention known as Device for Autonomous Bootstrapping of Unified Science called DABOS, which was created to generate invention. But that particular patent application was rejected in several jurisdictions except for South Africa. So you see that, I mean, there was a controversial conversation going on where people were like, oh, is it because South Africa is an African country that no one wants to follow their footsteps in terms of allowing non-human or something that is not a natural person to be recognized as an author of an invention, especially where AI was used. So one thing I would like us to know is that when you're talking about AI, I mean the conversation is just focused on what AI has done in the 21st century. But you find out that since the 90s, and initially when AI, when the concept came about, it was basically, it had the basic concept of solving issues. You put in your prompt, you get your output, that's it. But now you're seeing that there are different versions of AI being produced where you have the weak, strong AI that they want to be on the same level with human, and you then are trying to do something that is impossible. My next conversation would be the case where talking about trade secrets now. So, sometime in April, there was this case that went viral about Samsung employees who accidentally shared confidential information while using ChatGPT at work. Now, one of the employee had um, put in information asking ChatGPT to check for mistake, that put the source code of that product in question. Another one requested for some code and code optimization. Another one supplied a recording of a meeting that was being used to create presentation. So you now see that while this AI tool can make your job easier, but you find out that it kind of gives you like a public domain um, concept where anything you put there remains forever and ever, and anyone can have access to it. So whether you're an employee or an employer, you now have to have policies that checkmate all of these things so that your employees are not doing things that might compromise your product. For that particular product, Samsung had not yet put out any publication that they were creating anything, but because the employees wanted to, probably they needed some help and decided to explore the chat GPT, and they ended up sharing those information, and it kind of raised some issue. And now Samsung has banned its staff from using any AI tool at all at work. So how does AI affect intellectual property? First, it can be used to facilitate intellectual property protection and enforcement, where by an intellectual property owner can use these tools to monitor the use of their work in within that jurisdiction or another jurisdiction. You can also help them for search, to analyze, to manage their IP data, to detect and prevent intellectual property infringement, and also kind of help them to resolve their disputes. It can also be used to infringing existing IP rights, whereby there's some sort of copying or distribution or modifying, which now makes enforcement issue difficult. Then it can also be used to create new works or invention that may be eligible for intellectual property protection. Some of the ethical and legal challenges of using AI for IP protection and enforcement includes that AI system may involve multiple actors and interactions such as the developers. So if you're a developer, someone hires you to help them build an AI tool. You're actively involved in whatever that AI does. Now, in terms of authorship, your agreement will determine whether or not you'll be acknowledged as the author. If you're a user or regulator, um, it may be a bit challenging for you in terms of allocating or enforcing the duties and obligations depending on the role you play. AI may develop and change over time, which we've seen that what AI started as initially is not what AI is today. Today, basically, we are fighting to share space with AI in the creative and in the inventive world as well. Systems that use artificial intelligence may be used across different jurisdiction and domain, including internet platforms, devices, autonomous vehicles. It can also make it difficult for you to harmonize and also implement your rules and regulation. Um, so another way that you can, so we're not going to delve into the data protection, privacy, security aspect of AI, and that it just goes to show you how AI has also involved. Now, some of the ways to safeguard privacy and security for AI system is one, you have to go through your data protection laws or regulation that provide guidelines and requirements for gathering, for processing and sharing of data on any AI system, as well as the rights and remedies for those people. I recall when I was talking about the weekend Drake case, one thing I forgot to mention was that another thing that was being considered when these conversations started coming up was rights of publicity with or right of publicity or what is also known as image right. Then conversation as to the kind of clauses that you may start to see in agreements that you have to disclose whether either as a songwriter or as a developer, um, whichever actor you are within that particular space, you have to now disclose whether or not you're using any AI related to. So when you're looking at it from the privacy and security aspect, you now have to make sure that whatever it is you're doing it in line with the laws or regulation of your country. Make sure you encrypt your work, protect your data and your system from any unauthorized access or modification by using codes or password, and also limiting the people that may have access to this information. And this is where trade secret comes into place as well, because it's what you take extra measures to protect that will be protected. If you don't do that, you end up losing it. Then you also do data protection impact assessments, which evaluates the potential impacts and response and risks of AI system on personal data and privacy, as well as measures and safeguards to address them. So for this, I referred also to the newly passed Data Protection Act in Nigeria, Section 29. I think when I went through it, this was one that came to mind, and I thought it would be useful for people that are listening to me today. Then questions that arise from the interplay of intellectual property and artificial intelligence. Remember, I talked about the handshake. So this is more or less like an interplay. They are basically marrying themselves. Now, questions like how can intellectual property right adapt to the advancement in technology and difficulties presented by complexity, autonomy, and unpredictable nature of artificial intelligence systems. So I'm not going to liken the movies we see, but sometimes in the movies you see that the AIs in form of the robots overrides and then they go against what they've been actually programmed to do. What do you do in that instance? Are there laws that already made to sort out the issues so that there's no you don't have too much liabilities incurred on you? How can also intellectual property right balance the interest of um, the stakeholders such as the developers, the providers of the platforms, users, and everyone that may end up being affected by any AI system and application, as well as the works and inventions that will be granted or generated by them. Finally, how can intellectual property rights protect and also incentivize the creation and innovation of artificial intelligence systems and applications, as well as the works and invention also generated by them? So, for the mid journey case now, how do you incentivize Christina, or is there some sort of commercialization model that people who use this tool can explore in terms of licensing or assigning their rights, or basically just going to collaborations and partnership? Now, remember, I talked about how these issues are built and how do you then resolve them. And from these three cases I have mentioned, most of these cases were resolved by the administrative body of the intellectual property offices, be it the copyright office or the patent or a registry, as the case may be. And they did all of this looking at the basic requirements that um, you need to look out for when someone makes a regular application. I call it regular, so we're not a bit confused. And then you find out also that they are also subject to appeal to the court. So when they're now appealed to the court now has a precedent. We now have a precedent in the system that people can rely on what to do when disputes like this start to arise. And I wrote down a couple of things that I didn't put in my presentation as I was going to share. Recently, the EU Parliament is set to have like the first AI Act, which seeks to regulate the high risks of AI systems and foundation models like the one which ChatGPT is based on, making it the first governing law. So check that act out. Also, there are other issues such as um, videos or deep fakes. I don't know how many of us are aware of what deep fakes is about. It's kind of a misleading, use tools that kind of mislead or um, interrupt or change the perspective or narrative that you want people to see. For instance, there was this AI picture that went viral that the Pentagon was on fire, or there was an explosion of some sort. Now, that particular picture caused some issues within the stock market. There was also another viral picture of the Pope in, I think it was a white, what's it called now? A white jacket of some sort, and then another one of Elon Musk as well. So you see that while you're still looking for ways to, um, you know, be abreast of what is happening, you find that AI is rapidly developing and evolving. Same way, and that puts pressure on IP laws such as the copyright, because you might create a law today that solves whatever issues you were dealing with. For instance, pre-COVID, we weren't having conversations on AI or NFTs or the metaverse. But post-COVID, especially last year, the conversation about the metaverse was so much, was kind of like in everybody's face. Same thing with NFTs, and now we are dealing with AIs. And when you go online, or if you're a creative, you find that there are several AI tools that are being created to make life easy for you. Now, when you do that, do you actually acknowledge that you actually use this particular AI tools? You have the right to actually commercialize all of this. So those conversations will keep having them, and that is why big tech companies are doing a lot of research. Countries are doing a lot of policy engagement and stakeholder engagement to make sure that they're not leaving any stone unturned. So, in conclusion, all hands must be on deck. We also have to explore the depth of this topic. I hope that with my presentation, I'll be able to convince you and not and not confuse you. But thank you, and I think my time is up.
Thank you so much, Rita. That was really interesting. And I remember coming across the case of the Steven Tyler. I know the case was held in the US, was held in Australia.
A lot
I
of
think the lower court,
jurisdictions.
lower court initially in Australia gave
I
him yes, and
yes,
then
it was
finally
upturned. It
when
was
it got to the
appealed.
federal court or what they call it was upturned. Yes, I remember following that case. And initially, when the Australian court granted him held that it was okay for an AI to own a copyright a patent or whatever invention, it was interesting to me because the idea is we were created. I know one of the quotes then was we were created to create. So
Yeah.
why shouldn't our creations be able to create? Something along that line. And it was really interesting. I think there was an article I wrote in school sometime last year with respect to how is the law changing with the changes in the society? Should the society change or should the laws change? Which one needs to bend ways to accommodate the other? And artificial intelligence in general was one of the things we considered. And I was of the opinion that the laws need to change to accommodate the needs of the society. The laws need to change to be able to accommodate the inventions because we are humans and we are bound to create and invent new things. So this topic of artificial intelligence and intellectual property is one that I don't think it's going anywhere soon because it's going to be creating so many controversies. Just like before now, it was just the issue of copyright and patents, and now we have trademark issues, we have trade secret issues coming up with it. So yeah, I have a few questions, but first of all, there is one here from one of us. She says, or he says, since AI more or less copies other works out there and mixes it to create something new, can you, which actually is referring to can AI really infringe on copyrights of another?
That's a very dicey question. I would not want anyone to misquote. Can AI infringe your work? So
Yeah.
let's start from the basics. Is AI a now or author? Whatever your answer is, I think that gives you an idea of whether AI can infringe. However, what we've seen within the last 1 year when you're talking about AI generated work is the platforms who create this work actually have terms and conditions. So I know for Mid Journey, I had an opportunity to go through Mid Journey because I was trying to understand what Christina was thinking about when she eventually came up with the idea of copywriting the Zara of the Dawn book. Now, there are certain provisions which states that you must clearly, you have to declare and be honest that you're using certain codes belonging to people that have put it on whatever platforms that you're using to, have your conversations on. Now, can you actually infringe? It now depends on the person who put in the prompt. What is your purpose for actually putting the prompt? Are you putting in the prompt to show people how creative you are, or you intend to monetize it? So let's look at it from the NFTs, case scenario where people were minting um, pictures and
The
videos
backing
and
bar.
gives. Yes, yeah,
Mhm.
like the meta backing case. Clearly, it
Yeah.
tells you that when you get into the virtual space, that's a different ball game. If you own the right in the physical world, you also own the virtual rights. If I want to use elements of your work, the main IP principle states you must get consent, permission, and authorization in writing. Now, under our copyright law, it states if you're going to get an exclusive license, it has to be in writing. Whereas for a non-exclusive license, you can choose to have an oral agreement or a written agreement or I'm trying to figure out the word. So it said by conduct, something like that. So can AI infringe a work? What is your purpose at the end of the day? Because if you're considering thinking of infringing on someone's work, that means you want to monetize. And fair dealing
Mhm.
principle in Nigeria or fair use in the US will not protect you at this stage. So I hope I was able to answer your question, but if I did not, you can always ask and I'll do my best to answer you again.
Yeah, I think one of the questions I have, which is one that has been also the topic of discussion, is who owns the right to an AI generated works or creation? Who 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 actually are we saying is the machine or is the individual? I want to hear your opinion. I have my opinion on that, but I want to hear your opinion. She said you answered her question.
That's fine. Thank you. So your question is who owns a generative work? I would say for me, the person who created the work owns it because when you're looking at copyrighted work or let's say IP in general, you have transformative and derivative, and all of that will depend on the use. What is the purpose of the use? For instance, our copyright law states that whatever quality the work is created in enjoys copyright. Even works that are anonymous now enjoy copyright protection under our laws. We do not have an exclusive law on artificial intelligence. Or when you're looking at generative AI work, I would say the person who put in the prompt in the AI tools such as Midjourney or ChatGPT owns the work. I think there was a post that someone made a few weeks ago. I think it's still going around somewhere where someone asked a question on ChatGPT, who owns the work that you create, and ChatGPT says you. So if you put in that prompt, you're already giving it an idea. I know that for authorship is whoever makes contribution to that work that is acknowledged as the author. But in this case now, you are collaborating with the AI tool, but your laws generally do not acknowledge AI as an author. So if, for instance, you're in a jurisdiction like the US where they put up um, the US now has a guideline for AI related applications. So you go through the applications and then you clearly state, and whatever the copyright commission decides will be final. If you don't agree with it, you can go to court and verify. However, there's also this case that is currently going around. I don't know whether it's a Germany case or German case or French case about where some artists put their content on a platform and they wanted to opt out of it, and then they ended up being sued for copyright infringement. So it's a bit dicey when you're talking about infringement and ownership of AI or generative work in this present era. Hopefully, we get closure by the end of this year on whether or not we are proceeding with being acknowledged as the owner of a generative work or just the owner of an IP work.
When you were talking about how AI affects intellectual property, you did mention that it could be used to facilitate IP protection and infringement. And I want to ask when one wants to do this, how are there any legal considerations? Are there any legal restrictions that one has to look out for when you're using an AI technology, to search for your trademark or to monitor any brand infringement?
So I would say there are some IP users, intellectual property officers, that are considering using AI tools to help them hasten search at the registry because we've had instances where um, someone makes an application for, say, a trademark or a symbol, and then in that particular jurisdiction, it might be distinguishing the mark in question. But in another territory or another jurisdiction, you're actually infringing on someone's cultural expression. For instance, the Timbuktu case, Yoruba case, that's a clear case that if AI was being used, I'm sure that they would have raised a red flag during the search stage. Then, in terms of IP owners using AI tools. I think you have a couple of companies that have been doing this. Maybe they weren't calling it AI tools, but they had um, products that were used to monitor the intellectual property belonging to their client. That when they get that bit that oh, this person's work is being infringed or there's a likely infringement, the lawyers do the job, send the C&D, and they take it up from there. Or they eventually, instead of suing after the C&D, they end up going to like a licensing arrangement. So those things happen there. It's now if you're not going to create AI tools specifically for monitoring infringement or helping at the IP registration stage or helping the IPUs, that's the owner of the AI tools who is creating it strictly for this purpose. And whatever data he's now getting from the registry, that conversation must be had as well, which is where privacy and security and data protection conversation will also be had, because all of this are, like I stated, they are handshake. This is a
Yeah.
handshake. They marry each other, they are together, whether or not they like it. You can't do one and leave the other. You have to do all of them at the same time. So you don't leave any gap or loophole for trolls, IP trolls that just like to have fun on the internet.
One other question I have here, but I think you've answered it, was the steps that one can take to safeguard AI generated works. But I think that has been answered in the sense that it just depends on your jurisdiction. We know IP rights are territorial in nature, and it depends on the type of IP protection you're seeking for. Most you could go to, I think UK is still strict with respect to recognizing AI works. They are still having issues with that. The US seem to be more liberal with
Yeah,
their
I
laws.
know that the UK, as of last year, had like a public call for
Yeah,
contributions on
yeah,
AI, what the registry can do, what the government
yeah.
can do,
They've
because
been doing that. They are
they've
yet
been
to come
doing
to
that a lot. They are yet
conclusion.
to come to a conclusion. But yeah,
Yeah.
the US is more liberal when it
Yes,
comes to all of
it's
this.
easier for them to always just insert one clause in their constitution to protect something they like. Yeah, so I've come to realize that. So basically, it depends on the jurisdiction you're dealing with and the kind of protection you're seeking for
Yeah,
when it
so
comes
the
to
same way
that.
IP is territorial, like I stated, whatever
Yeah,
you're doing, make sure that it's in line with what the rules and the laws provide within that territory. So you're not dealing with cross-border dispute. Cross-border dispute it might seem big, but it's not too big, because if you narrow it down, the governing law will always decide who should, regulate the
yeah,
dispute in
yeah.
question, whether you're going to court. I purposely did not mention ADR because I feel resolving AI related disputes via ADR will not, there won't be publicity about it, because it's still a growing area. We need those precedents to be set.
Yeah.
However, in an instance where maybe someone steals another person's AI codes or something and is worth $1 billion or
Mm.
$1 trillion, please let's go to mediation or arbitration. Seriously, because that's the type of tech related dispute that ADR would specifically love to handle.
Yeah, true. And I think with respect to this protection of AI or providing some form of intellectual rights for AI generated works, it will be easier to deal with when it's under maybe copyright or trademark. I feel patent will be more difficult given the nature of inventions, especially like
I think if
I know now.
you streamline it to the claim. The claim is what determines how the invention itself will function.
That's the thing. But now, just like when this person asked, though she restricted her own question to copyright, the fact that AI copies another work just to create another work. I know for patents now, the issue of Priority Act is now global. They no longer restrict it to just national. So a situation like that, an AI generating a work, and then they're looking at issue of Priority Act. What if the issue of Priority Act was not done by AI? It was just the normal form of invention. And then what happens in that case? Do you
Oh
understand?
well.
What
Oh
happens? How is that
well.
going to be resolved?
Let's see that. So you see that, and I'm going to refer to the big countries now, the likes of China, the US, Korea, South Korea to be specific, the EU as well have been doing a lot of investment in terms of creating AI products. Now, when you see all of these conversations they had, and then you now restrict it to just patent, you find out that at the examination stage or the search stage or whatever stage, the examiners will do their due diligence in verifying that your AI is actually innovative or inventive or is novel. It must meet the basic requirements, whether or not you like it. So even if it's taking the examiner a long time to get back to you, you just need to exercise that patience with them and know that it's something that they need to do, because unlike other IPs that the examination may be easier, to deal with, like, okay, are this logo similar? What is the position? This is this book, whatever, all of this comment. The expression, is it original in nature? For patent, you are looking at the claims, and looking at the claims, you're looking at how the person has labeled it, one, two, three,
Yeah.
comparing it with another one that may be before you. So using AI, if the patent registry now during the prior art stage decides to use an AI, to the AI to just basically analyzes the documents in front of them, and gives their opinion, makes the decision for them. But the human person looking at that still also has to make the final decision as to whether what the AI has proposed is actually the right thing and the right decision for them to follow. I don't know if that answered your question.
Yeah, it does. It does. We don't have any more questions. Do we have? Is there anyone who wants to ask any other question before we close? Before we round up? Anyone? Okay, nobody. But if there's any more questions, definitely I'm going to be forwarding them to you. So do you have do you have any final words for us? Do you have anything before we come to a conclusion?
Final words, please. Let's research more on the topic.
Yes.
I
And
mean,
it,
the
so
potentials are there for Africa to say, creating all of these tools to solve our issue. We don't need to imitate the bigger countries. We have our
mm,
own peculiar issues. We need to Africanize whatever AI tools we'll be creating, whether it's in Kechi or Obi you want to create, whatever. But make sure that the tools you're using original. Same thing for the developers, same thing for the owners at the end of the day. And I think with time, our registry will be more open to using AI tools to hasten IP registrations, because we need to know that at the end of the day that you can't rush an IP registration. An examiner must do his duty to ensure that the IP in question, whether it's copyright, trademark, patent, or design right, which all requires registration, must meet the basic requirements. AI is good, no doubt, but I mean, let's be realistic with our conversations on AI and be a bit gentle with the regulators. Engage them more. I think they are ready and willing to learn. It's not a fight between Gen Z and Gen X or whatever gen out there. But yeah, I think that's about it for me.
and I think I also think our laws need to be updated. I think we're with the people we
Shey,
copy our laws from update theirs and we just remain where we are, and it's really
shey we
sad.
just Buhari gave us a gift. We had the new Copyright Act. People should
Yeah,
enjoy that
that
for
enforcing
now.
it is another thing. I think that the major. I tell people Nigerians have laws to cover just about anything. Our major problem is enforcement. Get our
But
major.
I think with the new Copyright Act, the Nigerian Copyright Commission is dedicated to actually educating the general public on this new act, because this new act is extensive. So when I talked about the takedown
Yeah,
procedure, it's under section 54
yeah,
to
you mentioned.
56. It's very detailed. So even if it's an AI work that you want to issue a takedown notice on, just like what the music record label did for the Weeknd and the Drake. So I think it may not expressly state in artificial intelligence, but then it's
Yes,
tech, and
yes. It's just
you feel is your copyright. So just make the application, and but then no need to bad. But this copyright law is actually really solid compared to the last one we had. So yeah.
it's a good one. I think it's just like filing for, like in the metaverse when you talked about filing for trademarks and the likes in the metaverse. Most people read the nice classification and they don't understand that some of the classes, I think class 45 and the likes, you could actually file for your trademark here for visual items and all that. But then I think the place we need major work is our patent registry.
I think they are doing fantastic. I
I
mean,
think
we now have utility patent, which wasn't in the procedure before. So if you have a product that you need to push out before say 12 months, you cannot explore the utility patent procedure to do your patent, but it must meet the basic requirements of being new, novel, not obviously skilled person, and has an inventive step. So, I mean, instead of us just saying, oh, this or that, I mean, the registry is doing their best. And I think, again, that we as lawyers, we also need to engage the registry more to actually understand them better. I mean, the general public can say what they want, because you find out that in Nigeria, it's just, and I keep saying COVID was a blessing in disguise, because pre-COVID, most people were not willing to have that IP conversation, save for the
At
big firms.
all. At
But
all.
post COVID, everyone is thinking IP. I want to patent these ideas. Ideas are not patented. They are not patented subjects. They're not subject matters of patent. You can't protect an idea, but you can
Expressions are
protect.
not even copyrighted either.
Yeah.
Ideas too far, yeah. So
So all of those conversations. I mean, the conversation will still have the conversation, but we
mm,
need to give the registry their kudos when it's due. But whenever
actually.
they're messing up, we just have to call them out. Yeah.
So uh, for just a last question, for someone who is trying to understand AI and intellectual property rights, are there any materials you could recommend or
Oh, there are
any?
lots. There are lots.
So if you
It's a
could,
lot.
I could get that from you, and then I'll forward it to those who are indicating interest, or forward it to the website, so that they could
I
go
think I
through.
think the easiest way to get material is Google. It's not how you ask the question. You have to
I
twist
was
the
about to
question.
say that.
You twist it, and
Yes,
you just get what you
I was
want.
about
And
to say
then you
that.
can also use. Should I even say? You can use. So, for instance, Bing or Binge has an AI research tool.
Oh,
So just put your questions and
hmm. I
whatever.
think another people to follow up is WIPO. They've been really having several conversations on this. Check out
Yeah,
the
even check out the UK
UK.
IPO
Just go to
AI.
gov.uk. Once you open the site, just
So,
type in AI or IP, and you will see loads and loads of materials. So, yes,
yeah, yeah,
those
I
sites.
agree.
Thank you, Rita, so much. Thank you for gracing us with your presence, and for
Thank you for
the
having me.
presentation. It was really interesting. Like, you need to see my book. I've jotted a lot, especially most of the cases you mentioned. So I'll have to go back to go through them. Thank you.
Thank
Yes.
you.
And
Thank
so,
you.
yeah, she has a very detailed IP series podcast. And she just mentioned that, yes, she does. IP series. You need to check her out. She has
Shay,
over
thank
100
you.
episodes. Over 100. So, guys, please just follow her. Follow her for more of these. You would really learn a lot from her. So
Thank you.
i- basically, what we're saying is the legal framework and discussions around AI and intellectual property is one that is still evolving. We are still learning, and different countries are having different approaches and regulations with respect to how to handle it. So it's something you have to just be updated, follow the trend, follow what's happening, and you, it's let me type it. It's called IP series. So just follow the trend and read. Reading is very important too. Even though some of us are lazy, you actually have to. That's one way to keep up with what's happening. And the conversations are a lot, so you can't even tell yourself, "Oh, I'm going to start so time." You realize by the time you start, something else has come up. So you just really have to start
True.
now to read and pick up. Thank you for having us. And if you have any more questions, let me please okay, most of the persons here on IP Business Capital. If you have any more questions, you could drop it on the YouTube live video, which I would always be able to access, and we'll get back to you. Thank you and have a good evening, guys. Thank you for having us.
Thank you.
Bye,
Bye.
Rita. Bye.
Bye.